You're listening to a Zone Radio podcast, zoneradio.co.za. All right, this is Zone Radio, 88.5, the voice of the valley. The time is just on 10 past 4, and as we promised you, we have Steve Reid in the studio as a guest with him. His name is Roy, and he's going to introduce him to us. It's all about patent law. Good afternoon, Steve.
Good afternoon, Richard, and good afternoon, listeners. And Richard's absolutely right. I met up with Roy Taberer, I'd say about 3-4 years ago, in a networking event. We've always spoken about networking, haven't we, Richard?
We have.
And have been engaging with Roy at different times. But Roy, maybe you can introduce yourself. Tell us a little bit more about yourself and Taberer Attorneys very briefly.
Good afternoon, listeners. Yes, thank you, Steve. Patent law and myself. I've been a patent lawyer for about 15 years.
Okay.
And it really came about as a result of my deep interest in innovation and invention and the stuffiness of law and getting out of that stuffiness of law and looking at people that invent.
Yeah.
And how I can leverage law and a bit of science with patent law and helping inventors.
Speeding up the process, which can be laborious. Amazing. And I remember, I think it was November last year, we were both at the Western Cape Entrepreneurial Recognition Award, or shortened to WCARA. And Roy, you were a sponsor. Talk to us about that. Why did you sponsor the event? And which of the 6 categories did you sponsor?
Well, thank you, Steve. Yeah, this was brought about, my dear wife. I mean, she runs my practice, and she came up with this idea that the Western Cape government was looking for sponsors in this particular event, and it just neatly dovetailed with what I do. And I am used to dealing with corporates, dealing with invention within corporates, but I needed to branch out and support the man in the street, that person that has that great innovation, that great piece of art, literature, invention, design, and say, come along with me on the journey, and I can just guide you through the process, through what would seem like a very difficult process, and just guide you through and get you to an end result.
Super. So, Roy, I'm going to look at some of the things that we wrote for your article that is in the book. So, when you introduced yourself, your tagline is your partner in innovation, and you spoke about that. So, tell us a little bit more about why that's such a cornerstone of Taberer Attorneys and patenting.
Yeah. So, your partner in innovation. Innovation is broad. Innovation just covers the breadth of the fruits of the mind, what comes out of your mind, your ideas, your creativity. And it's in there that the practice of patent law fits.
Yeah.
And so I'm going along and I'm saying, we need to assist these people that have great ideas. And I'm there to say, okay, patent law, very, very, very comprehensive. I can simplify it. I can get you over the line. I can get you hopefully a patent, a design, a trademark, or copyright. Those are the categories.
Fantastic. I remember I think they were 2 Israeli young ladies, I hope I'm getting my facts right, who invented a straw that when you drink through it at a party or something, and you have that's been doctored with a so-called rape drug, it changes color.
Right.
Amazing. I mean, that's such a out there thought, but so practical.
So practical, yeah.
So using that as an example, would that be something that would be patentable from that to what's some other areas that you can share, that you've recently got involved in?
Well, that's fascinating, yeah. So that would certainly be patentable, if it's not been done before. Remember that to get an intellectual property right, patent, trademark, design, copyright, it must be new.
Okay.
Okay. So you must be the first person that invented this idea. And this idea then must come about and you must express it in some material form. It can't just remain in your mind.
Yeah.
You must express it on paper. That's where the patent attorney comes in. You must express it in some physical form, some manifestation. And the patent attorney will try and categorize it for you. The things that I have come across are varied. I mean, you go from antiseptics, which is very topical in the COVID generation, biodegradable antiseptics, through to lingerie, through to rock bolts, industrial rock bolts that hold up deep level mines.
Sure.
And it's extremely varied. And that is, just to digress, one of the reasons why this is such a fascinating field, because every single day, there is an inventor that's coming in with something that is brand new.
Something strikes me there. In the talk that I used to do for Race Corp at the Pitch and Polish, one of the things was to refer to these two guys. They're in a bar and they're chatting to each other, and suddenly the TV breaks away from the sport, and there's this guy receiving one of those big checks, both physically and in numbers, 5 million rand. And the one guy turns to the other and says, you know what? I came up with that idea 5 years ago. Roy, what's the difference between the guy on the TV and the guy sitting here? And there are many people, who come up with ideas. What's the difference, would you say?
That's a great question. So I can't remember if it's the guy on the TV or the guy sitting, but the guy who's going to get the rights and he's going to move forward is the guy who takes action.
That's it.
It's action. It's all about action.
Yeah.
So sit on your idea, have it in your head, and do nothing. Is going to take you nowhere from a business point of view, and coupled in that from a legal point of view, your legal business rights it's not going to advance. You're going to have something, you're going to sit on it, and you're going to be worried that, and this is typical of an innovator, an inventor, having a great idea and sitting on it for fear of someone
copying it.
Yeah. Inertia sets in at that moment. So that person must be a person of action. Okay. Take that first step. Come to a patent attorney. Have that patent attorney have a quick look at over what that innovator has done. See whether there is a right that can be protected. But most importantly, for that patent attorney, which I want to do, I feel that this nudge him in the right direction. Just say, maybe you haven't got anything that can be patent protected, but you've got a great business idea. Go for it. Go for it. Yeah.
Sure. Excellent. And I know that you encourage people, if you're going to share the idea, and ultimately you have to test it, you have to share it, so you've got to do it with wisdom. But if you're going to do that, it's okay to ask to sign a, what is that?
Yeah, non-disclosure agreement.
NDA. Yeah, non-disclosure.
And absolutely, that is a wise piece of advice, Steve. So, I mean, that inertia sets in. You're fearful that a person is going to take what you disclose. There are ways of protecting yourself.
Okay.
If you're going to share it with a small group of people in a private setting and you're canvassing those people in that group, an NDA is probably the best way to start. To just give yourself a little bit of peace of mind. One thing you cannot do is disclose broadly, disclose to the public, come on radio, advertise it in the newspaper, sell an article. Once you've done that, your opportunity of patenting, get design protection or whatever is
almost none.
Is ended. Yeah.
Okay. Yeah. Okay. So I'm sure that our listeners have got lots and lots of ideas. They say that everybody in their lifetime, it's one of these broad statements, everybody in your lifetime will come up with 2 opportunities to make amazing amount of wealth. But the problem is that most people don't see that. They don't recognize it as an opportunity. It comes disguised in overalls called work. So what would you say to those folk who've got an idea, and it could be a game changer? And let's also say, let's be wise, not every idea is tomorrow's Facebook or whatever, Microsoft. That's just the reality. Coming up with an idea is not too difficult. Implementing it is very difficult. But for those folk who are, some people are almost, they just come up with ideas all the time. What would you say to them? How can they begin to test that? How can they begin to test themselves against the opportunity?
Yeah, not keeping it to yourself. And, or we go back to what I've said and what we've been discussing, where it's fear. Surround yourself with sounding boards. Surround yourself with people in the know.
Okay.
Let them listen to your idea. Let them give you their opinion. And slowly but surely, coalesce those opinions around your idea, where you'll slowly but surely start formulating an invention, if it is an invention, as in a technical solution to a technical problem, or that great business idea, which may not necessarily be patentable, but still innovation. Surround yourself with that expertise. People like you, Steve. Patent attorneys can help, but they can only take you part of the journey.
Yeah. Thank you for that. And actual fact, just because of the role that I have and my colleagues at the Centre for Entrepreneurship under the college, we are honor bound and policy bound not to take any participation in that. So that's a bit of a reassurance. But I also think, when you're surrounding yourself with people, it's around making sure that they are people of integrity, that you can trust, etc. So, be discerning, but at the same time, be willing to share is what I hear there.
Spot on.
Yeah.
Absolutely.
Right, I have a question. Now, we're talking about patent law, and just give people a definition, a top-line definition of patent law.
I'm going to give you. I'm going to backtrack a bit and say, let's go for intellectual property, and then I'll go for patent law. Intellectual property covers 4 classes: design to industrial design, the look of things. There, I'm thinking Carol Boys and the new, amazing, a design to everyday articles. Copyright, works of art, works of literature, your book, Steve.
Okay.
Then and computer programs. Then we have trademarks to brands. And finally, patents, which are to inventions. And inventions can be defined as a technical solution to a technical problem.
Okay, so that defines it for folk. I just wanted to get that clear in people's minds. The next question is when, now I've got an idea, when do I go and say, all right, I need to take this to a patent attorney? At what point in the process? Do I have to do the designs? Do I have to do the drawings? Do I have to do all of that? Or do I just say, I've got this idea and I think it's workable? At which point do I say, I need to go and see Roy?
Yeah, that's a very, very good question, because people wait too long. You don't have to have a prototype, and that is a popular misconception. All you need is that technical solution to a technical problem, which can just be theoretical, could be on a piece of paper. You've done the maths, you've worked out the tolerances, and you've said, this is my solution. That is a perfect time to come and get a patent attorney to draft an application, get your foot in the door, establish some sort of priority to that invention. Things will evolve from there, because the patent process allows iterations from there.
Okay, now the patent process is not a short process. And at which point, once we've come to see you, at which point is it safe for me to try and take my idea to market, or start disclosing it to other people's or role players that I'm going to have to get involved in it without fear of it being, stolen from me? At which point am I safe in that process?
Safe from the moment, really safe, from the moment of filing.
Okay.
Rather than the moment of grant. And as you rightfully said, and between filing and the grant of your rights, of your patent rights, can take many, many years.
That's the patent pending.
That's the patent pending period, because it's an application, and you have officials that are examining this and will finally, hopefully, grant you that right. So don't wait. And it is so frustrating at times when you hear people say, but I'm not doing anything until I get my patent rights. No, time is of the essence. Time is, use that time to steal a march on your competitors and get going. So filing the application, get going.
So once it's filed, you're going to pick up the phone and say, go for it.
Go for it.
All right. Now, having done that, having gone through that whole process, there's this term patent busting. I'm sure you've heard. And it's a rather contentious one, because there is a view out there, how accurate that is I don't know, is that if you take the design of an article, and we see it in the market, because there's so many products that look similar and do similar things, but yet are different by just some tiny little design element. Is that a patent bust? Is it that easy?
That all depends on how much you have separated yourself from what came before. If your invention is wafer thin, then all you're going to get is a wafer thin claim to the invention, and therefore you can't claim more than what you have invented. And the claim, which is a word claim in the document, claims that little small step over what's come before.
So it actually spells it out.
It spells it out.
It says, okay,
Sure.
this spray bottle in front here, there is something similar.
Yes.
Your one is different in that there
Elements.
is a bigger nozzle on it, or whatever
That's
the case
right. There
may
is
be.
a novel element. And if that novel element is large, you get that rather broad protection.
Yes.
If it's a small inventive step, let's call it an inventive step over what came before, then as a consequence, your monopoly and your patent rights are small.
You see, now that answers a question that I've had in my mind for years, because I was always of the belief that if you just took anybody's patent and you looked at it, or a design aspect, anything,
Yes.
can be that squeeze bottle over there, and I did something just slightly different, I am protected against the person who holds the patent. That's not true?
No, it's
Yeah.
not. It's not necessarily
Yeah.
true. Yeah. So really, what it is you may think that you've got broad protection, and as an infringer, you may think that you are infringing just because you've made something superficially similar that may even work the same way. That's where it becomes technically quite tricky, because you need to get the patent document, and they are published. Once a patent grants, it is open to public inspection, and then to look at those claims and compare it with the infringing article.
Okay. Now, I think my final question is this one. So, I'm a lunatic professor that invents things. I've got like the tinfoil on the head, and I go out there and the little whirlies on top, and we're going and we're just creating stuff. I'm just creating things, and I'm taking it off to somebody like you, and they're revolutionary and they're different, and but I never do anything with them except patent them. How much protection is a person allowed to go and invent something that maybe change the face of the world? Let's say, for argument's sake, the electric car concept. And if that was patented and never actioned, would anybody else be allowed to make an electrical car if the person who holds the patent hasn't done anything with it? Do you get where I'm going with this?
Absolutely.
Yeah.
So you're sitting on an invention, and that invention may have global consequences.
Yes.
The world may need your solution, and you're sitting on it. You're being rather selfish. There is in all patent laws, as far as I'm aware, national patent laws, this thing called compulsory license. It's never been exercised in South Africa, but it is available in the statute for that example where you can get a compulsory license if something is of such importance and so on, and the patentee is so mean with his patent.
Yes. But if it's not of national importance or anything like that, and it's a smaller thing, it could be for a dinner table or something like that. You still, the person can sit on it forever, and it's there.
It's your property.
Yeah.
You can do in your house what you want to do. Same with a patent. It's your piece of property, and it cannot be expropriated. If that's the word. It's not. You can't take it away from the person because he's not using it.
Okay.
Very different from trademarks, though.
Yeah.
I have a different thought on that. And that is, if someone is, as you said, the woolly-headed professor,
That's me.
and is creating stuff, it doesn't mean that you are an entrepreneur. It means that you're an inventor. It means that you're an innovator. And what's really smart is, in gathering people around you, gather someone who can scale it, gather someone who can drive the business side of it. You know, it's a bit much to think that someone will come up with a great technical solution to a technical problem and be a whiz-kid at selling.
They may just be a selfish person, which is what I'm getting at, and there's no way around it.
Yeah,
and that is such a good point, Steve, because the patent registers around the world are just littered with patents that no one's using. And people are reinventing those that are already on the patent registers that have never seen the commercial light of day.
Yeah.
A patentee needs to be surrounded with good business people, people that can take that to product and market.
I seem to think that some of the universities have got things that have been invented and patented, but they're waiting for, and I'm not sure how the law is enacted here, but they're waiting for someone with a drive and the entrepreneurial nous to come and take this and take it further, because the person who invented it just does not know how to do that. So if I'm correct in thinking that, I think that that's also a place to mine for the entrepreneur that could. Yeah,
that's right. So entrepreneurs are focused on innovating their own solutions, whereas their solutions are already there.
Sure.
You just need to find them, and you need to approach them, the owners, and get a license. Yep. And the universities are a great source of that patent mining.
I wanted to ask you mentioned trademarks. Is it very, very different to a patent?
It is. It is. So a patent's technical solution, technical problem. So you're talking about generally, let's call it machinery or pharmaceuticals. Trademarks to brands. And there you're thinking of well-known brands, for example, Nike and Coca-Cola, really well-known brands. In South Africa, Standard Bank, etc., are great trademarks. Brands, trademarks. There, because there is only a finite number of words or combinations of words, someone can't sit on a word or a combination of words and not use it. So get that word or combination of words registered, but then sit on it and not do it. So in trademark law, it's very different. You lose it if you don't use it.
Okay. All right. Okay. And if you change it, you lose it.
If you change it, then you're not using your trademark. Yeah.
Okay.
Yeah.
Right. That's very interesting. Yeah. And is there anything about trademarks that longevity gives you a right to it? Or do you take Zone Radio. We've got a logo that we've designed. We've been running with that logo for 10 years. If somebody else wanted to use that logo, do I have any protection?
Yes.
Without having gone to see somebody like you, can somebody just use my logo?
Use your logo? No. Certainly not if they take all of the characteristic features of your logo. You have what is called common law rights. So when we talk about trademarks, it can be your rights can accrue to you by virtue of your common law rights. In other words, you've used it over years. You've gained a reputation, but you've got to prove reputation. If you don't have a reputation, then that's the link between the mark and it being proprietary to you is reputation. With a registered mark, you don't have to prove reputation. Once you've filed the trademark, it is granted, you get those rights, and you then just assert your registered rights. So there are two distinct types: common law rights and registered rights. So the trademark application process for a registered right gives you a statutory right. You've got common law rights. It certainly does mean that you've got something, but you've got to prove reputation.
Is it an expensive thing to do, registration and patents?
That's relative.
Yeah,
it's really relative. It can be, but it's not necessary. People are surprised. It's relatively cheap, and they have these ideas that patenting, trademarking is hugely expensive. It's not. It's not. So when you start the process, you're looking at a trademark application, in the thousands, 2, 3, 4,000, depending on the trademark attorney you go to. For patents, it's more like 10 to 20,000 for a first filing. It does get expensive if you want to take your patenting process externally to other countries. So there, you're now multiplying that cost.
Yeah, by the number of countries that
by
you're
the
going to
number of
protect yourself,
countries.
yeah.
Correct, because one thing is that trademarks, patents, and designs are territorial. They're granted in a country, and you only get rights in that country.
Right, that answers my question. Thank you.
Sure. So, brilliant. I think we're coming in for a landing.
Yes.
And my final question to you is, because you've got that link with innovation, what would you say to our listeners and to those who are just kind of thinking they haven't yet come up with an idea? Can you think of any secret sauce that would encourage thinking innovatively? I mean, it's the area that I love, but can you think of, as a patent attorney?
Steve, and there you have ambushed me, and I'll tell you why. Because I think I am the most uninnovative person on the planet. I cannot innovate my way out of a plastic bag. I really can't, and I that's why I'm on the other side.
Okay.
I wait for the creative people to come to me.
Ready?
Yeah, for me I'm not the creative type. I would never ever say that it is inherent in everyone to be creative. I think that, but once the juices flow, creativity, that those creative juices flow. Inventors invent prolifically once they've started.
Thank you for your candidness and openness. But let me say this just to our listeners. Here's one thing that you can do. I remember Elon Race from Race Corp saying, think about something that's completely disparate. So you're thinking of, let's say, you're thinking of transport, and then you think address, and there's normally no way that fits. But when you start to think, well, how could it fit? What could be the combinations, etc.? A rugby ball and a pair of sunglasses. I know it sounds a bit like, really? What is it? But because you start to think, and it's almost as if you place yourself, well, I'm obviously not seeing it, what else is there? And you ask questions.
Yeah.
That's when sometimes different solutions.
Yes.
By the way, just personally, I love it. I love going for long walks and just thinking, not necessarily thinking about inventing something, but it's sometimes on those walks that a solution comes. So I would encourage our listeners to get innovating and get producing these game-changing ideas.
Well, I'm just looking at the two of you in your shirts because they're so similar. I was just wondering who's got the patent for what here. I mean, it's like you got up this morning and phoned each other.
We both got the memo.
I both got the memo. This has been fascinating. It really has been, Roy. And I think that, you just touched the tip of the iceberg. And I think that for you, you're a very lucky man to be able to do what it is that you do. Even more lucky to be able to express it the way that you do. But to be able to be privy to all these great ideas and all these amazing minds must be a great reason to get up in the morning and wonder what the day holds for you, because you really can't tell who the next crazy professor is that's going to come through the door.
Absolutely.
And it must be very rewarding for you. Not that I've ever thought that the work of an attorney is rewarding for anybody except the attorney, but for you, it must be very, very rewarding to be able to say, when it hits the shelves, or it's, this piece is on a rocket to the moon, that, I was involved in helping that process forward.
Lovely.
In a meaningful way. I think that's got to be one of the most rewarding things, and I actually envy you for it. I really do. I really do.
Yeah, no, it's amazing. It really is. And just what you said there, going around the shopping centres and with my wife in tow and saying, I was involved in that, and that shelving system there, and that product there, that disinfectant, that's got that special formulation there. It's fascinating. I love it, and guys just keep inventing. South Africa needs inventors, creators.
I want to tell you a story. I studied, for my sins, I studied theology at a place called Heidelberg College. And at Heidelberg College in Somerset West, we had this policy of doing our own manual labor. And if you misbehaved for any reason, broke the rules, you were given hard labor. And hard labor could take the form of anything. And in my case, there was a lot of it. So I got to do curbstones. Okay, lay curbstones on a road that goes up around a church that they built up there. And at the time, I wasn't very happy about having to lay these curbstones and give up on doing whatever else. And today, it's a great, it's a wonderful memory, but it's also something that is permanent. It's something that is so real that I can take my son to the campus and say, listen, boy, see those curbstones there? See how nice they look? I did that.
Gee.
And that is something that I can talk to you about once in my life. But you can do that just about every single day in every single place. And I think that is absolutely amazing. So thank you for your time this afternoon, really. Appreciate it.
It's been an absolute pleasure. Thank you.
Thank you so much, Richard. Thank you, Roy.
Steve, we'll see you back in 2 weeks' time.
Yes, indeed. And we're going to be bringing another entrepreneur who's an HR person.
An HR person. All right. Well, that's going to be very, very interesting. I'm looking forward to that. But your sessions are always very, very good, Steve. And we thank you for your time. And again, Roy, I think that we definitely need to get you back because, trademark we haven't even touched on. And that is probably one of the more common ones for an entrepreneur because, not everybody's inventing, but they have designed a brand or they've got an identity. And I think, Steve, sooner rather than later, if it's okay with Roy, to get him back to speak specifically on trademark because I think that would affect a lot more people than just patent.
That's right, Richard.
I do thank you for your time. And I will see you in 2 weeks' time. Here's a fellow called Papa Satch. He's going to play us out with 1 to 2 runs. Thanks, both of you, gents.